There is a 99% chance that the officer involved in the Minneapolis shooting will not even be charged with a crime or charged with violating department policy.
It's not clear to me that shooting the gun and killing this woman eliminates that threat as opposed to making it greater. Like, where's the intuition that that will actually lower the threat?
And so Batman says, or reasonably, his friends are in imminent threat of death or great bodily harm.
Right.
And so arguably,
all right, Mr. Counterpoints.
Before we fight,
yeah,
I don't want to fight.
I don't want to fight.
Okay, but before we fight, can I show you?
Yes, you can
my
show me
claims.
Yeah, show the drawing. Oh,
can I show you the tactics that I think are bad?
Yes.
And then can I read you the police report as if I was writing it, and then can we fight? But can we be knights?
Yes. You can definitely show me all this. Yes.
Okay. So let me pull up my Microsoft Paint. Let me show you my Microsoft Paint, and then because this might actually assuage some of the butthurt people in your chat. It's not going to assuage my chat. They've been fighting me on it all day, but it might assuage some people in your chat. Okay.
Yes.
Here are my 3 claims. There is a 99% chance that the officer involved in the Minneapolis shooting will not even be charged with a crime or charged with violating department policy. Mm-hmm. My second claim is, if on the 1% chance the officer was put in for administrative action for violating departmental policy, there is a 1% chance he will actually be fired for said violation. And then number 3, if on the 1% chance the officer is charged with a crime, he will not be convicted of said crime. Can you just acknowledge that I've made these statements and these are my claims?
Yes.
Okay. Now, with my drawing, these are the vehicles. Okay. This is the ICE SUV. If you can see it on your share screen. Here's the Jeep. Here is the other thing. I can't really do the angles. I wish I could. I know the angles are wrong. But what happened was these 3 ICE agents approached the vehicle from the side and said, hey, you need to get the fuck out of the vehicle. Then this guy put himself in harm's way by approaching the vehicle and putting himself in front of the vehicle, which is not advisable. Then he fired 3 shots into the driver as the driver tried to pull away. I think the driver was trying to flee. I do not think the driver was intending to hit the law enforcement officer when she was doing so, or at least that wasn't her aim. Her aim was to escape. Her aim was not to kill a law enforcement officer, right? Mm-hmm. You with me? Can you just acknowledge what I've said so far, even if you don't agree with details?
Yeah, I acknowledge what you said.
Okay. Then tactically, what I would say is that there's a couple of mistakes here. Number 1, from a tactical perspective, I'm not talking about policy. I'm not talking about law. Tactically, it would have been more sound for him to move his vehicle in front of the detainee's vehicle, because that would be less likely for him to get hurt or killed and therefore put himself into a deadly force encounter. It also would have been more tactically sound for him to approach the vehicle from the passenger side window. That way, if the vehicle attempted to flee, he would not have put himself in a deadly force encounter. He could have given lawful orders to the driver, and if she flees, it's law enforcement. Sometimes people get away. You don't have to kill every single person you interact with just because they're fleeing law enforcement. I'm acknowledging. Can you just acknowledge, I suppose, instead of digging into it?
Yeah, I'm acknowledging everything that you've said. Yes.
Okay. Then one more thing. It's a little bit longer, but I'll get it done, and then you can start tearing it apart as you see fit.
I don't want to fight, but yes, go.
Okay. So Officer Nasty, kind of a lib douche who likes to split between our communities. He likes to trigger the fuck out of me and mine, and then he likes to run back to yours.
Who? Is that his username? I don't know if I've ever seen him.
Gen X. I think Gen X was snitching on Officer Nasty, saying that Officer Nasty was in your chat talking all kinds of shit about me a few weeks ago.
Okay, if that happened, I didn't see it. Gen X. She's like a. What is she doing?
Yeah, Jen Winkler's my spy.
Okay,
I'm her like 3rd favorite streamer. So. But so what Officer Nasty brought up was the Department of Justice policy, and there's a few key elements of the policy that I think are relevant. And there's one section that's arguable. I think there's 2 sections that are not arguable. So the 2 sections that are not arguable. Law enforcement, when the officer has a reasonable belief that a subject of such force poses an imminent threat of danger of death or serious physical injury to the officer or another person, is when you can use deadly force. And then there's a subsection about vehicles. And within the subsection, it says the vehicle, in order to justify the use of deadly force, the vehicle is operated in a manner that threatens to cause death or serious physical injury to the officers or others. I think that those two thresholds had been met. But in that subsection, it has an and clause that I think could be argued back and forth. And the and clause says no other objectively reasonable means of defense appears to exist, which includes moving out of the path of the vehicle. I think that's where the contention is going to be. Now, I wrote up a fake police report as if I was the shooter. And if you'll indulge me one more minute of ranting, I'm going to read it to you and then we can fight.
Okay.
So on such and such date and such time, there was a person that Officer X was trying to detain. I parked approximately 20 feet in front of potential detainees at a 45-degree angle to prevent the driver from moving forward, and then exited the vehicle to help Officer X detain X person. As I approached the vehicle, I heard Officer X give a lawful order to detainee X to get out of the vehicle. We were wearing our bulletproof vests with police clearly marked on our vests. Officer X exited his patrol vehicle with lights activated, notifying detainee X that they were lawful law enforcement officers conducting legal law enforcement operations. As I was approaching the vehicle, I heard detainee X shift their vehicle into drive and turn their wheels towards me. It was at this moment that I believed that I was in threat of either death or great bodily harm as a result of the actions of detainee X. The incident unfolded in a matter of seconds, and I had no other objective, reasonable means of defense. I did try to move out of the way of the vehicle defensively and was almost struck by the front end of said vehicle as detainee X attempted to drive forward. I pulled my service pistol, serial number XXX, and fired several shots into the driver, attempting to stop the threat. The driver was incapacitated and crashed approximately 50 yards south of our location. At that point, we detained person Y, Z, and X for questioning. So, I've given you a lot. Give me some feedback.
Yeah. I don't know. What do you want to talk about first? Do you want to talk about policy? Do you want to talk about whether we think this is self-defense?
We'll probably fight more on morality or what law enforcement officers should be authorized to do. But I would like to hear if you had any objections to my three initial claims that, number one, I don't think he's going to get charged. Number two, in the rare chance that he's going to get charged or put on some kind of disciplinary thing, he's not going to get fired and he's not going to get incarcerated or convicted.
When you say you don't think he's going to be charged, yeah, I think that they're not true. The first is that it's a 99% chance he won't get charged. Maybe I would agree with that if you just mean federally.
So what, you think the state is going to charge him?
I think more likely than not they will, yeah, with something. And because I basically think that's almost like
at the state level.
That's a different question. Let's deal with the charging question first. Like the charging question is one that is almost in some sense like political. I think that it would be there's a lot of pressure on the AG. I think who's Keith Ellison still, right? Hang on, let me just check. Keith Ellison. There's going to be a lot of pressure on Keith Ellison to bring charges in this case, where I think even looking at this from a lens that's police sympathetic, I think that there's at least a more than plausible case of some kind of criminal homicide here. So I just don't know where you're getting this 99% from. I think the state is very incentivized to bring charges. They brought charges against Chauvin. I know Chauvin was a state officer, but I don't know where you're getting this confidence that the state won't charge him.
Yeah, so I guess I'll amend my statement for I think 99% the feds aren't going to charge.
Okay, yeah. No,
okay.
I would say 100% chance that the feds are not going to charge him.
Well, then even with the state, I would throw it up 50-50. And the reason why I would throw it up 50-50, which I know is not enough confidence to bet on, unfortunately, but the reason why I would throw it up 50-50 is because I think that there is a lot of movement from Democrats effectively saying, like, we don't want ICE. We don't need them in our communities. They're actually harassing our community members. They're putting themselves into harm's way in reckless and cowboyish ways. And so as a result, like, I do think that that is possible, politically possible. Well, I would still stand by my 99% there's not going to be a conviction, though. So what do you think about conviction?
Yeah, conviction wise, I think it's a little bit early um to make those kinds of determinations. And so I'm going to just as a preliminary determination, I think if this ends up going to a trial, I think it's nowhere close to 99% he won't get convicted. You just need to convince. I would probably put the odds in favor of the officer at this point for sure. Given the burdens of the state, you need to prove beyond a reasonable doubt. I think the burden of self-defense even shifts to the state at a certain threshold of evidence in Minnesota. I think I recall that that's what was the case was in Chauvin, that they, as a matter of state law, and again, query whether or not federal self-defense common law would apply or federal self-defense principles would apply here, as opposed to state law principles. There's some weird issues of federal preemption, but ultimately this is going to have to be justified with some sort of self-defense principle or defense of others principle. And I would lean in favor of him getting off if this goes to trial, but not where I'm talking like 60-70%, nothing like 99 or 100%.
So
And that's preliminary
let's talk about
the
the report then, and also the departmental policy. So and here's the other thing too that I want people to realize while we're talking about this. Policy and legality are not the same thing. So there can be people who violate departmental policy and are either held accountable administratively or even fired from their jobs, but then are not incarcerated or convicted for violating the underlying policy. And so an example that I brought up earlier in this conversation with my chat is there was an Orlando police officer. You could probably Google the case. And effectively what happened was they were trying to detain a felon on the second or third story of a parking garage downtown. There were shots fired up top, and the cop got his AR-15. He was on the bottom floor, and he waited by the exit with his AR-15. And then when the fleeing vehicle was exiting the parking garage, he mag dumped it. He put like 30 rounds into the vehicle as it was leaving. And so what happened was he was able to get acquitted at the state level. I think he was charged, but he was acquitted because he said, oh, well, I heard all this radio chatter of people getting, shots fired, and maybe people got hit by the car, and it's a felon who's fleeing and eluding. Sorry, one second.
Tell her I said hi.
Okay. And Pisco says hi, Mrs. Points. She didn't say anything. Maybe she hates you now. I don't know. But the point is, with that law enforcement officer, he was able to articulate in court and say, oh, well, I thought it was a fleeing felon, and I thought there were shots fired up top. And basically, I thought that since he had already used his vehicle as a weapon, maybe he would use his vehicle as a weapon again. And so his state charges were
very
ultimately dismissed.
Very different facts.
Right. Of course. But then I think we can get into the facts of this case where effectively, yes, this cop put himself in harm's way, but I still think he has a easy articulation of imminent threat of death or great bodily harm to himself.
Let's talk about it. So, and I would prefer to talk about it not from the perspective of the jury and from our perspectives, unless you think there's a reason we ought not do that.
No, we could talk about our perspectives. Wait, did you say which one that you would we should put more weight on?
No, I would prefer that if we're going to have a conversation about what we think is reasonable, what we think represents a risk, that we do so from our perspective, as opposed to saying, well, a jury could hear this and a jury would be convinced and a jury could say this,
Sure. Can I mute myself in our conversation so I can call one of my viewers an Arsler real quick?
Yeah.
Okay. So much crazy. Okay. Jamestown Sassacre, you fucking dumbass. I will skip the Arsler analogy, okay? Not even in the same galaxy. That was what your example was when asked for identical analogy. Laugh my. As a matter of fact, fuck you. How about that?
I'm stealing this content.
How about that? All right. I timed them out.
All right, cool. Yeah, we heard a little bit about that. I didn't hear you use the Arsler.
I didn't. I said dumbass instead of Arsler.
All right, cool. All right, so that's my proposal. I think that oftentimes these conversations get confused when we start talking about like, well, don't you think a jury of 12 people will say this? Don't you think a lawyer could make a convincing
Yeah,
case about
I'm not.
that?
I'm not going to obfuscate.
Yeah,
I will specifically tell you
if and
what
when.
I think
Yeah,
happened, and then I can specifically tell you what I think a jury is likely to find. I will differentiate, and I will not jump back and forth between the two to confuse the argumentation.
great. And I guess the last thing is, how do you want to approach this? My tendency is
I just want
always
to know what Pisco thinks.
okay. So I'll give you my case. I think that for me, whether or not this person was smart to get in front of the car, whether or not they're violating policy, is not super relevant to my determination. I think what's relevant to the determination is the legal standard of use of force and specifically deadly force. And I understand that standard to be both constitutional and oftentimes statutory and policy, but at baseline, it's constitutional. That the use of deadly force when inflicted on a human being is a seizure under our Constitution, under the Fourth Amendment, and like because of that, we need to apply at a bare minimum a constitutional standard. And that standard, roughly approximated, there's different distillations of it, is the following: that an officer is justified to use deadly force if and only if, or sorry, in the context of self-defense, if and only if there is an objectively reasonable officer in that officer's position would feel that it is reasonably necessary in response to an imminent threat of serious bodily injury or death. That's what I understand the standard to be for deadly force. And so the question is whether or not what we saw fulfills that standard such that he is justified in his use of force. You with me so far?
I'm with you so far.
Okay. I'm also not analyzing whether it was smart to be in that position, either from the cop perspective or from the decedent perspective, whether or not they have the authority to initiate the stop. I assume that the DHS does have the authority to make stops of crimes that they see that happen in front of them. And for whatever reason, whether this is a pretextual stop or not, I think they have authority to do this. And I don't think that she has authority to like leave. So I'm not analyzing that either. The only question is whether or not deadly force is justified under the law. And I'm not assessing the morality of it at the moment. I basically think there at no point was he in a threat of serious bodily injury or death, given what the car was doing and given the direction of the car. I think that there are cases that suggest that for precedent, but also beyond that, I think that the use of the firearm is not reasonably necessary in virtue of the threat, even if it did exist. That is to say, at no point would shooting the gun and killing this person be reasonably tailored to stop the kinds of threats that people are talking about. And then finally, I would say on all of this, there's an importance for us to take the perspective of where he was standing, so from his vantage point, and also from an objective perspective as well as subjective. That is to say, an objectively reasonable officer in his position, what they would do. So given that, I think it doesn't fulfill the standard, and therefore, since there is no justification, murder.
So let's break down the components then. And by the way, you guys are. Some people are agreeing with me. Some people are agreeing with Pisco. These are actually just the arguments that are going to be happening between a state attorney and a defense attorney and a grand jury and a judge and all that kind of stuff. Is this specific issue, was it reasonable, or I think you used the term objectively reasonable, that there was an imminent threat of death or great bodily harm? Okay. Yep. And so now we have to get into
one other thing.
What is
you need to analyze the application of force at every moment in which it's applied. And so every shot needs to be accounted for. Now, you could say, well, the shots were in such quick succession that we should consider the perspective,
which I would say.
Okay. But that is just to be clear. Every single moment needs to be accounted for, every single use of force. That was true of the Chauvin trial.
Well, and let's,
as well as
let's account for them. I actually just got done watching the videos earlier this morning. Like I watched it last night, but I obviously I got done watching it at quarter speed this morning. Mm-hmm. So let's break down death and great bodily harm, because I actually think that a lot of people don't understand the latitude that is given with the term great bodily harm. Okay.
Mm-hmm.
So death, I think we all understand death. It's like the cessation of life. It's the cessation of like normal bodily functions to the point that that person is not coming back. So we understand death, right?
Mm-hmm.
And then great bodily harm, there's a huge latitude here. And what I mean by that is that great bodily harm, I do have a knife, but I'm not going to do anything crazy with it. So if I have a knife like this, and if I was to slash my skin right here, even if it was just like a superficial slash where I just had like a very shallow 1 millimeter cut across my arm, it wasn't near an artery, it wasn't near a major part of my body or whatever, that would still be considered grievous bodily harm because I have an implement that is capable of causing great bodily harm. And not just that, I'm using it in a circumstance, or potentially using it in a circumstance in which it can cause
where there's a significant risk of it. So yeah, in that case, I would agree that that situation is one in which there's a serious risk. There's a risk of serious bodily injury, given the implement and how you're using it. In that, so I understand a serious bodily injury to refer again, the condition of having serious bodily injury is one in which there's a high risk of death, or there's some kind of like potential for a permanent or long time disfigurement.
We could focus on great bodily harm instead of death, because I think if we keep getting wrapped up into death, then what's going to happen is my chat is going to be like, he was at no risk of dying. He was at no risk of dying.
I'm just trying to define,
no risk of dying, but they're going to ignore great bodily harm.
I'm just going to no. I think that let's just get it's a lower standard for serious bodily injury. So I'm happy to go to the lower standard. This is from Josiah. Sorry, Minnesota investigators are saying they can't access evidence, and FBI won't work jointly on the probe. Noam just confirmed she doesn't think the state has jurisdiction. Both your thoughts. I mean, I think that's an insane thing for the DOJ not to cooperate with the investigation, and then for them to say that the state has no jurisdiction here. I think that's absurd. And I think that's just crazy and wrong. I don't know if you have any takes before we get into our discussion, Counter.
No, I think the problem is that the conversation about what we're talking about is obviously within the further context of like mass deportation operations by ICE and the Trump administration being one of the most like authoritarian and corrupt regimes in recent American memory. So when we zoom out and people are like, well, this is within this context or whatever, I understand the context, but I think I'm focusing on the details.
Yeah.
Of like effectively deadly force or imminent threat of death or great bodily harm. This has to be argued for all of law enforcement for all of time, regardless of what standards we set as a society. So even if we say cops are never allowed to use deadly force or never allowed to think about death or great bodily harm, we still need to talk about why, regardless of what's happening in the broader context.
But in terms of the Chrissy Noam's jurisdiction thing of what she said there, do you have any response to it? Just
I mean, fuck her.
Yeah,
fuck the feds. They should comply with the state level investigation because the state, regardless of whether or not you think the Democrats are being too soy or the Republicans are being too barbaric, the state should have the right to investigate a crime that they think happened in their jurisdiction, and there should be cooperation between the feds and the state. It should not be one-way cooperation.
Got it. Yeah, no, I agree with that. All right. So on serious bodily injury, or I don't know, serious risk of bodily injury. Sorry, it's risk of serious bodily injury. So my understanding, and here I'm pulling up from a federal statute, but I think it more or less maps onto I think there's one additional thing I would add here. But this is how the federal law defines it in a given statute involving the Health and Human Services. That the term serious bodily injury, it means bodily injury, which involves a substantial risk of death, A, or B, protracted and obvious disfigurement, or C, protracted loss or impairment of the function of a bodily member, organ, or mental faculty. I would add to that any injury that is likely to cause great pain. I think that there's a pain aspect to it as well that needs to be included. So I would even go broader than that. But basically, serious bodily injury includes injuries where there's a serious risk of death, a substantial risk of death, or where there's like some kind of permanent disfigurement or some kind of like significant pain. That is how I understand the term.
So let's focus on those last two. And I understand that what's happening as we're moving down the death or great bodily harm thing, I'm actually going down to like the lowest threshold for death or great bodily harm. I understand that as we're conversating, but then this is like a simple question that I think is actually conceptually pretty simple. Can a slow moving vehicle cause death or great bodily harm? Focus on that question in isolation.
So the question, can it? I don't think that's the question you want to ask, because
I think the answer is a firm yes, right?
Well, it depends on what you mean by can and what kind of vehicle you're talking about. So a slow moving vehicle,
I think an SUV is okay. I think a Jeep can cause serious death or great bodily harm even at a low speed.
So I think that a slow moving vehicle can cause death, in that it is possible for it to cause death. I think that throwing a cup at someone
or great bodily harm.
It's possible for that to cause death or great bodily harm. So we have to speak not just in terms of possibility, unless we mean something else.
Sure. Yeah, and we can get into the probability, right? Because it's imminent threat. Threat probably has some level of possibility in like calculated into it. Something that a chatter asked me earlier was, if the vehicle was 100 yards away, but it was charging the officer, would he have the right to fire? And I said no, because of imminence, like it's about to happen. And then also like proximity. Yeah, of course it's possible.
No, I think that is,
could hit you.
I think that's a clear case of self-defense. If you have a vehicle
shooting a vehicle that's 100 yards away,
if you have a good reason to think that it's going to come, that he's charging towards you, I think that's a much stronger case of self-defense. Why? Because the person who is firing the weapon, presuming that they're good enough shot that they could like reasonably, hit the target, they're under a reasonable apprehension that the person is using the vehicle in such a way so as to intend to put them in serious bodily injury or death, and that increases the likelihood that that will actually be the case. They're moving at a high velocity of speed. That's what I'm assuming for the hypothetical, and you're at such a distance such that shooting and hitting him actually is likely to decrease that risk, right? So we're zooming in on a hypothetical. I still want to zoom out and get to our standards here, but just to be clear, in that situation, I think it's a easier case of justified use of force.
Sorry, I want to divorce this real quick because I see what you're saying, but I want to divorce it real quick. Okay. So the situation in, let's say that we have like a roadblock, right?
Yeah.
And then cars coming at you at a high rate of speed. You already know that it's like fleeing another law enforcement officer. They have a violent felony, something like that.
Oh,
let's say they've already rammed another vehicle.
Yes.
Then contextually,
easy use of force.
You probably could.
Yeah. That is, to me, is much.
You could probably open fire at 100 yards.
Correct. Yes.
Right. But I think what I was trying to articulate, because within the departmental policy, there was this thing where you weren't allowed to fire into a vehicle that was coming at you unless there was like no other reasonable means up to and including getting out of the way. And so I think that's kind of what I was getting at, was if you're 100 yards away, and let's not presume intent. Let's say there's no context. There's just like a car that's just driving a little erratically.
Oh, yeah.
100
No,
yards
not
away.
Justified. Yeah, no, not.
Then no.
Yes, correct. Yeah.
Right. I just wanted to divorce that mentally for people.
And part of the rationale there is, it's not clear if the person's just driving erratically and doesn't seem to have any kind of design, that shooting them is going to eliminate whatever threat exists, right? Think about the following situation. You've seen Watchmen. I brought this up yesterday, and I think it's a nice hypothetical. Suppose that, you've seen the ending of it with Ozymandias, and he's already launched his plan or whatever. Suppose that for whatever reason, you're in the blast zone of this Intrepid device that's being used, and it's already gone off. Like the timer, the kill switch has already gone off. It's just a matter of time for it to blow up and where you're at. You would agree in that situation, you are in imminent risk of serious bodily injury or death, right? Because you're in the blast zone of this device that he's already triggered it, okay? And you have him completely under your control. Let's say even he's handcuffed. It wouldn't be justified to shoot him there, right? Notwithstanding the fact that there's a threat to a serious bodily injury or death. And,
Oh.
no, I mean legally.
Yes, I know. No. I hate it.
No,
I hate it.
The reason
so
is
much. I have tears.
I know,
I have tears gathering at the corner of my eyes.
So let me finish it. Let me finish it, and then I'll let you respond and react.
Yeah.
The reason is the deadly force in that instance isn't going to ameliorate the threat. It doesn't actually address what's going on. And so this is one of the big issues in this case, which is like, okay, even grant that he was at risk of serious bodily injury, which I don't grant. I just want to say, I don't actually believe that he was in this case. But even grant that he was, it's not clear to me that shooting the gun and killing this woman eliminates that threat as opposed to making it greater. Like, where's the intuition that will actually lower the threat?
Yeah, no, that's actually that's very well argued, and I kind of want to reemphasize that for my chat, because this is actually like mad funny, because we do see this with like Superman. We see this in Superman movies. We see this in law enforcement movies, where for Batman, as a matter of fact, the most obvious example is actually Batman with Joker and who's going to become Two-Face? I forget his name. Harvey Dent and his girlfriend Rachel, right? So for those of you who don't remember, Joker set up 2 explosive devices with people that Batman loves on other parts of town, and so Batman says, or reasonably, his friends are in imminent threat of death or great bodily harm.
Right.
And so arguably, if killing Joker would resolve those hostile situations,
it would be justified.
Then
legally.
it would be justified. But killing Joker actually does nothing to save Harvey Dent or Rachel. And as a result of the self-defense claim being necessarily a defensive measure, therefore killing the Joker is not justified, even though he's on the verge of murdering people.
It's really,
that's wild.
It's really
that's
fucking
wild.
important, and I think it applies in this case. It's different than the case of where there's actually a lot of precedent for the cases in which someone is engaging with the police in like this miles long high speed chase, 100 miles. He's hitting cars. He's showing a careless disregard. He's driving so erratically that there's a threat to the public. In those situations, obviously shooting eliminates the threat, because the threat is like broader. The threat is either A, he's fleeing from one of these like inherently dangerous felonies such that the flight by itself needs to be stopped in and of itself. So like if someone is fleeing from a murder, you're allowed to shoot the murderer just on the basis of flight. Okay. And a similar thing when there's a public safety rationale in the context of a high-speed chase where the person has already shown a careless disregard to the public, then of course shooting that person eliminates the threat, because we're talking about a broader risk. Likewise, in a situation in which there's a car charging towards you where you can reasonably apprehend the intent, then yeah, shooting and like there's nothing around you that you have to worry about, shooting him would make sense, because the threat is not just of the car, but his design upon you, and killing him will eliminate the design upon you such that it will eliminate the risk towards you. Again, all else equal. But in this case, right, the kind of risk we're talking about is like the risk on being clipped and like maybe your foot gets run over or whatever. And it's not clear to me in this context, even assuming that we would meet the threshold for serious bodily risk of serious bodily injury, which is the lower standard. That's why we're going with it. That the shooting is reasonably necessary in response to it, because I think all else equal, it potentially could make the risk worse. The truth is, as she was dying, she floored the fucking gas and hit a car. And so I'm just not convinced that even if there is a qualifying risk, that the shooting at all lowers the risk. If anything, I would almost argue that it makes it bigger.
No, I'm tracking what you're saying. I think it's an interesting insight, and not only is it an interesting insight, I still stand by what I said with like 99% not federally charged, 99% not charged with policy violation. State level charges is a 50-50 because of the fraught political environment we are in. But I also think he won't get convicted. But what I think is interesting about what you're saying, and let's get into the moment of the shooting, the when it's actually unfolding. Okay. So what I think happens is, because I was in law enforcement for 4 years, And I would say we probably got deadly force training quarterly, maybe even monthly sometimes, especially if there was like a recent shooting. And then we also, deadly force was probably like 30% of the academy was like unironically deadly force because it's such a fraught topic. And so let's not bring in any analogies. Let's talk about the situation. So I think what happens is with imminent threat of death or great bodily harm, I could pull up half a dozen to a dozen videos of slow speed vehicles running someone over slowly, going over their legs, and then, or going over their head, God forbid, and as a result, causing serious bodily harm or maybe even death. And so, also because the situation is unfolding so quickly, where the guy is effectively in front of the vehicle, he moves to the side of the vehicle. Maybe he gets hit, maybe he doesn't. I wasn't able to determine that from the footage. Fires into the vehicle.
I think that, I don't know for certain, but I am not convinced he gets hit at all.
Well,
to me, it doesn't matter that much because I think even if he's bumped or if there's contact, there's not like a per se rule that if you get contacted by a vehicle, you can fucking unload your mag, because you still need to make the determination, especially because the shot at most happens simultaneously with the alleged hit. It's not like before it. And so if go for it.
Well, I was just going to say, this is where the effectively, like, I mean, I've seen jury instructions for like officer involved shootings. Like the presumption that people involved in unfolding adrenaline filled detentions, arrests, shootings, and fights is bullshit. That there's no conscious thought going on in this short of a time. Okay. So there is not, because the video is what, like 15 seconds. At 9 seconds, when he's in front of the front left headlight, he's not thinking to himself, oh, if I get run over right now, this is imminent threat of death or great bodily harm, but I do have enough time to step out of the way. Therefore, department procedure dictates that I step out of the way instead of firing my firearm. Oh, wait, hold on. I'm pulling right now, and the car has driven far enough that it's about to hit me.
Yes, you know,
therefore, I no longer have deadly.
I get it. He's working on instinct. No, I understand. Yes, no, I understand that this is what's so alien about this to a lot of people. I'm not saying for you, for a lot of people, because what you're saying is true. This guy, it's not almost certainly
not alien to me. I'm sorry. I'm just trying to agree.
But like when we pull apart these situations, we are doing a kind of like post hoc Sunday or Monday morning quarterback type situation where we're saying, oh, at this half second, what were you thinking at that moment? That's just like, unfortunately, though, the standard for analyzing self-defense is to break things apart in a timeline and to think what an objectively reasonable person would be thinking at that moment, not in the terms of reciting the formula of deadly self-defense and the policies as such, but what they were perceiving and whether or not we agree with the outcome afterwards, the decision afterwards. And so, yes, I agree. It's a little bit alien and weird, and it's like not at all how cops are like trained or how people think in response to different like emerging situations that happen in like literally 2 seconds. But unfortunately, like that is the task that we're called upon to do.
Well, maybe you and I have different presumptions about what's reasonable, but what my reasonable thing would be, and by the way, I've already brought up the 2 training mistakes or what tactical mistakes that I think this guy made. And by the way, we're like trained on these things to like, don't step in front of fucking cars. That's how you die, dumbass. But I think that he's performing a lawful law enforcement action, which is the detention of somebody. He's assisting fellow officers in it. He sees the car go into gear and start driving towards him, and he thinks, fuck, I'm about to get hit by the car. That's deadly force. Pop, pop, pop. That's like the entire scenario. There's so many things that you can break down outside of that calculation. But for me, that's the thought process is I'm doing my job. Car's coming towards me. Oh, fuck. Pop, pop, pop.
But it's not pop, pop, pop. It's pop, run alongside pop, pop.
Dude, I don't think so. I think we looked at the time unfolding. It's like less than a second between all three shots.
Yeah, but
It's maybe a second and a half.
He takes a few steps when he's clearly on the side. The question is,
He's already walking. That has nothing to do with it.
Would an objectively reasonable officer in his situation know that at the time he takes put aside the first shot, which I think is not justified, but even just to say I granted it, would an objectively reasonable officer in his position, walking alongside the car and taking two shots, know where his body is in relation to the car? And I think the answer is yes.
But you're already adding more thought than was already involved.
No.
He's getting out of the way as he's firing. He doesn't know whether or not he's going to get hit. And again, the shots elapsed are under a second.
There is a point in time at which he is perpendicular, right? Like the vehicle, if you drew a line from him to the vehicle, it would be perpendicular. That is to say that the car is on the side of him. He is in no sense in the path of the car. And he's firing into the driver's side window. Okay. And for those other shots.
Let's move him. Hold on. I have a way to illustrate why I don't think this is going to work and why I don't think he's going to get convicted.
No, let's just talk about what you think. I don't want to talk about what the jury will say. Okay. Let's just talk about you and me.
Yeah.
Okay?
Let me tell you exactly what I think. Okay. So I've already told you that he's made two tactical mistakes. One of them was if he was going to pull in front of the vehicle, he should have done so in a vehicle so he didn't prompt a deadly force scenario. Okay. That's mistake number one. Mistake number two is he should have approached the passenger side so he was not in front of the vehicle causing the deadly force scenario. Okay. I want you to hear those concessions before I make the next point.
They're not that valuable to me because I don't consider them that much in my analysis of self-defense here. So,
I know, but people like to.
It's a virtue signal for me. I mean,
frog.
I know, but it's lost on me because to me those facts aren't that relevant on either side. So
I understand, but I have somebody who's like literally in my chat, so you can jump in front of a car and cause a deadly force scenario like that. That's the response that I'm getting. So so maybe that's not for you. Maybe that's for the audience.
Got it.
Okay, but we're here now where we're standing in front of a Jeep that's trying to turn right, but we're in the path of the vehicle. And realistically, this entire thing elapses in under 3 seconds, right? Mm-hmm. So let's say that instead of stepping to the side of the vehicle and firing, which elapses in under 2 seconds, right? Let's say that instead, the taillight, because we are talking about a matter of inches, maybe less than a foot. Let's say that the front taillight actually clips the officer. The front wheel goes over his
front
foot
taillight or the front
ankle.
Light. Sorry, maybe I don't know.
The headlight. Excuse me.
Got it. Yeah.
So let's say that the headlight actually clips the officer on the hip, and his foot actually goes underneath, or foot and or shin goes underneath the front wheel, and then as a result, his foot, ankle, shin gets crushed. And by the way, you do have arteries that run down the entirety of your leg. And so as a result,
if that thing happened, what would I say about that? That would be serious bodily injury. Yes.
Right. And so my point to you though, hold on, I want to affirm this point before you counter argue, is if we're talking about seconds and if we're talking about inches, then the jury typically defers to the cop. And I'm saying the jury is right to do so, and that's what I think.
Yeah. So in that situation,
that as well, I think that deference is appropriate.
Okay. So you're at the time the shot is taken. I will argue to you, and I think it's true, that he's clear of the vehicle's path at the time he takes a shot. The first shot.
Sorry, what do you want me to understand about that?
Yeah. So given that if you believe my representation, that at the time he takes the shot, he is not in the vehicle's path. That is to say, the vehicle is not about to hit him. On what view would the firing be justified?
I think that we need to, in order to fight this, we would need to pull up the camera. And then also, we would probably need to know whether or not he was hit, not have an opinion on whether or not he was hit. We would need to know. And then also not just that action and reaction.
Well, no, hang on a second.
Different.
So if he's hit, assuming he were hit, I don't actually think he was, but if he were hit, clipped, bumped, there's contact, whatever, however you want to say it, that wouldn't justify an after shot if he's no longer in the path of the car. Agreed? Let's say that he's like bumped a little bit, right? Because there is contact between.
If he was standing to the right side of the vehicle and he gets hit by the windshield mirror, he doesn't have the right to pull his pistol and shoot the driver in the face
when he's no longer in the path, right? Even this is assuming that the shot is reasonably necessary in response to the threat. Again, we haven't got over that hump about, to the extent that there's a threat there, how does shooting her...
We should address that.
Yeah, so how does shooting her alleviate the threat that you just said you
Well, hold on. You're skipping a step ahead. I want to go back one step. So action reaction. Okay. So let's say that you and I are standing in front of each other. And then, as a matter of fact, we could probably do this. So I'm going to like slap in front of the camera. I want you to try to slap me before I slap you. Okay. But you cannot move until you see me move. Okay.
Okay. And this is over Discord, over internet, but yes, go ahead.
Okay. Okay. It's over Discord and it's over internet. But this is pretty well documented that reaction time is about a half second to 1.5 seconds behind what's actually happening. Okay.
Okay.
And so the whole point right there is the thought of this car is about to hit me. I'm pulling my pistol and firing. That is a half second to 1.5 seconds after what's actually happening. So the tail light in the car being past him by the point that he's already firing, his body's already moving to that reaction anyways. He doesn't even have the capacity to stop it because his thought of reacting to the vehicle and pulling the trigger and pulling the pistol, that was a full second to 2 seconds before he's actually pulling the trigger. And so that's why juries get, again, I agree with this. This is me saying it. But again, this is why juries oftentimes give cops a lot of latitude, specifically for incidents that unfold in less than a few seconds.
What about this? Okay, even if I granted that, I don't grant it. What about the second and third shots?
I don't know why you wouldn't grant that.
I don't grant that the lag period in between when it becomes apparent that he's not in the car's path, and when he takes the shot, is, I don't have a good basis to believe that lag period justifies an action when he's not in the path of the car. That's my response.
Well,
to that. I think he would know
the video and actually check the time.
Okay, you want to do that?
And then also here's the thing too. Same thing with the first round. You and somebody else in my chat said, cops are responsible for every round and you have to evaluate.
Yes, they are. Yes. Wait, you don't disagree with that? That's true. That's true when we say that. Yes.
I agree with you that each shot has to be evaluated. I also think that because
there's no lag period there.
Adrenaline. Hold on.
No. Objectively reasonable.
Hold on. All right, I'm joking. Because of the latitude of adrenaline, there's routinely been law enforcement officers who have mag dumped suspects, and every single shot was ruled justified.
So there have been situations. There's been situations where mag dumps are justified,
and they miss like 3/4 of the time.
Yeah. I'm not saying that it's never justified. I don't think you heard me. I'm saying in this case, where we're not talking about someone where there's a gunfight, where there's a criminal who to be dangerous, where you're just trying to shoot and kill the person, and where we're not going to like fucking analyze every fucking second of an AR that you're firing off or whatever. What we're talking about here is in broad daylight.
Hold on. I need to yell at somebody else in chat. Hey, Officer Nasty, suck a fucking dick. All right. I'm going to make sure that your chat hears this too. Connor should just let Pisco talk properly. Fuck you. Did you work in criminal law, Pisco?
I did a couple white collar criminal investigations, but that's all defense work. So no.
Okay. So he did 3 cases of defense for white collar shit. I did 4 years in law enforcement. Same Pisco. I should just let him talk. You can eat a fucking dick. Here's a 24-hour. How about that shit, Officer Nasty? All right, continue.
Sorry. I'm sorry. It's just
See, I told you I'm a tougher moderator than you.
yeah. Clearly, listen. I'm not trying to discount the cop perspective. All right. One of the reasons why Counterpoints' contributions are valuable is what his experience brings to bear and his history and all this stuff. So I'm not trying to say this I don't have to agree with everything it says, and you don't either. But I don't think that we should be like, oh, just let Pisco talk, because there are certainly things that Connor knows more about than I do.
These arguments are going to be had by if a prosecution is brought. Exactly what Pisco and I are talking about is exactly what they're going to be fighting about.
Officer Nasty's now in my chat. I said I told him to stop cutting Pisco off. It's okay. It's okay. You don't need to. We don't need you guys to moderate the discussion, okay? But I appreciate.
Officer Nasty, eat a dick. How about that? All right. So hold on. So you were. We should move. Yeah. I think we should move to the most interesting thing that you said, which is that deadly force should be used to ameliorate the threat.
Right.
And if it doesn't, then it's probably not justified.
Correct. Yeah. So how does shooting her in that moment get rid of the threat to the officer to the extent of, him being hit or whatever by the car, clipped?
Well, and I think that is arguable from your side, because, for instance, like even in the scenario that I bring up, in which the officer is struck by the front wheel well and run over by the tires, like even in that scenario where I made it more extreme by moving the officer one foot to the left.
Yeah, how does shooting to the left? Now you could imagine where like this
shooting her, because you're already under the wheel.
Right. So if we had a reason to believe that this person was gonna back up on the guy or did a crime in which they've already shown that they're doing it, like there are definitely facts that could get me there, where but it's having to do a lot with the state of mind of the person who, like, in the perception of the state of mind of the person behind the wheel. Think about the Darrell Brooks case, right? The Darrell Brooks case is where the guy who used his car to kill a bunch of people in that Christmas parade because he was like fleeing, I think, some domestic charge or some shit like that. It was absolutely stupid. The guy was like a sovereign citizen in the trial. It's a disgrace, and the guy's a clown. But in that situation, if you're a cop seeing, oh, he's hitting people, yeah, okay, firing the gun might achieve that aim. But here it's like kind of like, okay, she might hit you with the side of the headlight, and even take your example where he's like literally being run over. It's not clear to me that the shooting will alleviate that or will address it. But anyway,
it probably wouldn't.
Yeah.
Right. Like the harm's already done. And I think that based off of context clues as well, based off of the context clues of they're conducting a aggressive law enforcement operation. This is a protester who has been harassing them, and that they're effectively like a 37-year-old white woman yelling at them and putting their car in front of them. That's not typically like my subjects. That's not my description, I suppose, for like who I'm thinking is going to try to use their vehicle as a weapon, against law enforcement. And so I think we have context clues. Why is everybody just spamming Epstein files in my chat? If you keep doing that, I'm going to ban you. Okay. I love the Epstein files. It's my favorite. Let's talk about it all day, but stop spamming. So I agree with you, but then if we look at the actual policy and if we look at the legality, then how is that a calculation for achieving a conviction? Because what I would say is that had not even been brought up. And by the way, once again, I've done probably out of a 13-week academy, we probably spent a month and a half on deadly force. Like we unironically, and we probably still talked about it all the time. And then we probably did monthly or quarterly training on deadly force. And yet I don't think I thought about whether or not your action as a law enforcement officer is legitimately actually going to stop the threat. I don't think I've really we might have talked about it.
It's usually like obvious, right? Whenever you have a suspect who is doing something erratic, shooting him almost certainly will stop the threat. It seems clear in most cases that what you're doing, shooting someone, restraining someone, applying your taser or any other kind of implement that an officer might have, or some kind of CQC, whatever the handheld things are, that those will have in their natural tendency the effect of quelling the threat. So it's usually something that's just like trivially obvious that it would tend to have that effect. But it's not clear to me in this situation, especially given what happened afterwards, where the shot happens, she's fucking bleeding out, and she crashes into another car. What if there's someone in that car? What would we say then? What if there's a child in that car? Like, oh shit.
No, I mean, that fucking happens. Philando Castile, just as an example, horrible police shooting. I think it was a bad shoot. I think the guy should have been fired. I think his daughter was in the back. His wife was in the passenger, and he fired down at a 45-degree angle into the person. And Philando Castile was, by all accounts, innocent. And he was killed, and the background was not calculated. And I think that cop should have been fired.
Yeah, and so why I think this is against policy. Why I think this is against policy. And again, it doesn't just because it's against policy to me. It's not like the most relevant thing. And I even think Connor is right when we're saying, like, just because it's against policy, like, it doesn't mean that the jury's not going to give the benefit of the doubt to the person.
That's
let's let me finish this part, and then I'll let you go. I promise I'll let you go. I'm just like, yeah, the policy stuff to me is relevant as to what experts are, or what people who tend to be in these situations with experience tend to think is advisable in the circumstance. And the fact that he's violating policy, and the fact that there's generally a rule against firing on moving vehicles, except for those exceptional circumstances, is likely because it's dangerous to do this. It's dangerous from the perspective of keeping the public safe, and it's dangerous from the perspective of actually stopping the threat.
Okay, so my question though is, let's say that I think that's an interesting moral calculation, which, by the way, isn't it kind of scary that I spent 4 years on the force and talked about this monthly, and we didn't even have that consideration? And you say it's because 99% of the time it's going to be evident that you trying to stop the incident, right?
Will have as its tendency that effect.
But does that, because like I said, I trained on this monthly or quarterly, and also did 4 years of this stuff. The fact that that wasn't an obvious calculation on my part, and I actually think I went to an excellent academy, how does that change the potential charging and or incarceration? Because if you want to say the training was poor, I'll agree with you. Like I said, there's two things. And by the way, I do have to leave in 10 minutes to talk to Ryan Getty. Just want to give you a heads up.
Yeah.
But everybody should go check out Ryan Getty, by the way. He's a liberal. He's a video essayist, but he did an excellent video essay on national conservatism. His name is spelled RyanGeddie. I recommend everybody check him out.
Yeah.
Shout him out.
We had him on Live and Learn. He was fun.
Yeah. Excellent guy. Or at least so far, he seems like an excellent guy based off preliminary. But my question is, we're talking about potentially holding somebody accountable for violating department policy, which I think is arguable. And we said for political reasons is not going to happen at the federal level.
Yeah.
We're saying that he might be charged at the state level. And so my question to you is, how does him not necessarily eliminating the threat and the elimination of the threat improving his circumstances, why does that increase or decrease or leave neutral his chances of being charged?
So how does him not being able to quell the threat with the gun affect our intuitions about whether he'll be charged? Well, I think because the people who are looking at doing the charging decision are thinking about the legal standards, and I think the legal standards includes this notion that you're responding to an imminent threat with something that is reasonably necessary to quell the threat. And so given that I think it's relevant under the legal standard, and given that the people who are making the charging decision are thinking about the legal standard as well as the optics politically, I'm just going to be honest with you, given that I think these are like elected positions anyway, the AG, whatever. I think that because I think it bears on the optics and I think it bears on the legal analysis, I think it's likely to affect the charging decision. Oh, that makes sense.
Okay, but I think the reason why I'm pressing on this, or the reason it's definitely an interesting angle, and I think it's something that cops should be trained on.
I'm just gonna ask you straight up. I'm gonna ask you straight up. Would shooting the person in that car in that moment, in your years of experience, have the tendency to make the threat less, whatever threat existed for that person in the front? would have lessened that threat in your mind.
Not unless I thought they were trying to use their vehicle as a
Right.
weapon against somebody besides myself.
Right. So given
Yeah.
so look at what you just said, right? You think that even if there was a deadly threat, qualifying threat, you think unless you had a reason to apprehend her intent as to you or other people, you don't think shooting would have in its tendency the effect of lowering that threat. That I think is. I'm gonna keep going. You can throw the wrench. I think that is you saying it's not necessary. It's not reasonably necessary in that it doesn't actually lower the threat profile for anybody.
But here's something that we got into with my chat earlier that I think is relevant to the conversation. So, as far as I know, almost every state in the country, we could probably look up the specific statute and see if there was something that was chargeable. But the deadly force standard almost across the entirety of the United States is imminent threat of death or great bodily harm. And we actually talked about how intent does not actually necessarily factor into whether or not you can take action.
No, I get that. That's why I said intent as reasonably apprehended by the officer, as reasonably understood.
Even if you understand this, I want the audience to understand this. So there are people who are like schizophrenic. There are people who have type 1 diabetes, and when unmedicated, they actually become like incredibly like defensive and aggressive and violent and all that kind of stuff. And it is not their intent to be violent with other people. They're clearly experiencing a medical emergency. And yet, if you bump into a scenario in which somebody who's suffering a medical emergency poses a risk to other people, then you're kind of allowed to take action. And then if it's a deadly force scenario, you're allowed to use deadly force.
Provided the deadly force would respond to that particular threat.
Well, hold on. You're adding that proviso, and you're saying that every time a law enforcement officer pulls the trigger, they have to be calculating,
is this thing going to actually
increasing or decreasing the likelihood that this threat is going to continue?
Wait, of course.
Well,
I mean, usually that's obvious.
She's more likely to flee and endanger others. Therefore, I should pull the trigger.
Okay, that's what you would have to. That's what you would have to have some basis to believe. And that's what you have in the cases of the people who are doing these high-speed chases, who are under the influence, who've already hit things before, who have shown this tendency. That's how those cases are useful, because in those situations, the cops will do this kind of bumping behind to do the spin outs. They'll have those like the traps that they lay out in front of people, or sometimes they'll actually have to shoot when they like get to a parking lot or some shit. And even though they're at a standstill or whatever, the guy looks like he's about to keep going, you shoot and kill, right? So in those situations, now you have a set of facts where, okay, even though I like a driver who is dying or dead is like a much more unsafe driver, I can justify killing him right now. Will stop it. It'll stop whatever's going on. But that's not what we have here. And what we have here is, I think there's not a good indication that she is going to represent some significant threat to the public when she drives off, and she has not shown that tendency, unless you're willing to say anyone, and this is what one of my callers said or tried to get to, and there's case law against this, anyone who flees in a vehicle is necessarily a risk to the general public.
Yeah, well, once again, like it has, for law enforcement officers, or at least the way that it was trained, it has to be, number one, it has to be like a fleeing felon to even meet like a statutory threshold in the state of Florida. And then I think per policy, it has to be a fleeing violent felon, because there's technically like
right, so you don't,
felons that are,
so you don't like, even buy this.
Shoplifters. Like if you steal $300 worth of shit, then you're a fleeing felon. But if you shoot somebody, if somebody's carrying like a big screen TV and then you shoot him in the back, then you're going to have, even if the law is written a certain way, you're going to have difficulty justifying that shoot to anybody else. I think it was actually, I think the fleeing felon statute was also written like in the late 19th, early 20th century as well. And it was more for like escaped convicts than it was for people who were participating in a crime. But hold on. So we are running out of time.
Yeah, we are.
But I wanted to nail this thing down because it's interesting and I want to think about it more.
Yeah, think about it.
But do you have any specific statute as an example? Because I could pull up the DOJ policy. I could probably find the deadly force statute for the state of Minnesota.
Yeah, you'll find the word. You'll find the term reasonably necessary. and that
Okay.
term implies a
You think
link.
that that's implying the threat
Oh
thing?
yeah, yeah. And I'll find you case law that specifically says this, and I'll try to find it. But right, it just should intuitively make sense to people that of course this is it, right? Of course that the force that you apply needs to be calculated in such a way as to actually quell the threat. Like it's not enough to just say, well, there's a deadly threat to my life. Okay, therefore I'm allowed to, I don't know, throw a grenade in a place where I'm not really sure that he is, right? So any kind of application of force needs to be tailored to the risk, right? Like imagine that you're getting shot at from one side, right? You're getting shot at from like one direction, and you pull your gun as a your service weapon or whatever, and you shoot in the complete opposite direction for no reason. You couldn't just say,
Right.
well, I was being shot, so I shot. Yeah, it was deadly force, so I shot. No, it would be like, no, the force needs to be tailored and have some nexus to decrease the threat. Now, we're gonna give some wiggle room. No, I'm not here saying you need to like be perfectly calculated in your risk and you need to be like a fucking cookie from Ned's Declassified, or you need to be like Spock. I'm just saying there needs to be some nexus between the action you're taking and its tendency to actually reduce the threat. Not perfectly, not in a perfectly efficient way, but just a sufficient threshold there. And I'll find some case law that suggests that. But I do think you should think about it, because and this is why the policies exist, right? The policy exists because we've determined that this kind of shooting, absent these other factors, makes everyone more at risk.
Yeah, so that's kind of where I'm going to need to think about it. And I'm also going to need to look up the statute and see it. I think that I still stand by what I stated at the beginning, which is, number one, I don't think he's going to get charged by the feds. Number two, I don't think he's going to get hit with violating Fed policy. Number three, I do think that there's maybe a 50-50 chance that the state would charge him based off of the political circumstances, not based off of what's actually going on. And I still think there's a 99% chance that he's not going to be convicted for actually exactly what Pisco just said, which is that you don't need to be perfectly reasonable in these scenarios. You just need to be reasonable enough. And I think that juries, which I agree with, to be clear, I'm not trying to weasel out of it. I think juries are given, they give cops a lot of latitude because of adrenaline, because of reaction time, because of the presumption that law enforcement officers are not this like vampiric class of parasites waking up every single day trying to figure out how to fuck over members of the public. There's a lot of things that slant juries in cops' favors during shootings, and I still think those things are going to be true. That being said, as far as what you and I think, I think you gave me a meaty morsel to
chew
consider. On it. Yeah, I got to chew on it.
Chew on it a little bit.
I gotta digest it. I gotta think about how it actually affects the case and if it affects the moral calculation and this, that, the other. And real briefly, I'll try to be as fast as I can. This is the reason why the Mike Brown case, for those of you who don't remember Mike Brown, he was like a large teenager. He got into a fight with a shopkeeper. He was unarmed, but a cop from some fucking place shot him dead. And allegedly he punched the cop in the face through the driver's side window of the police officer's car before they got into their fight. The lack of training, I think, leads to homicide is just defined as people killing each other. There's a moral weight to it with us, but homicide is actually, even justified homicides are still homicide.
Homicide, yeah.
Right?
Yep.
So I think law enforcement officers can be so reckless that they contribute to homicides, and that is immoral. And that can be lack of training, that can be recklessness from the law enforcement officers, et cetera, et cetera. I think that
they did a bad thing. Yeah, no, I understand what you're saying. What you're saying is he contributed inappropriately to the unjustified increase
the situation
risk, and therefore contributed to some respect to the homicide negligently or recklessly.
And in some ways, indirectly or directly caused the homicide. And I would make that same argument with Mike Brown, that if you have somebody who just robbed the store, then it's negligence to drive up to the suspect, roll your window down and say, hey, did you just rob a store? Because you're basically, you're forcing a confrontation when you're not ready for the confrontation. And as a result of that recklessness and stupidity and lack of training, you actually probably ended up causing the homicide. So yeah, it's not that cops can't be criticized. I think that I just get frustrated with my liberal chat when they're like, they just assume that something like this is going to happen, and then a jury and a judge and a state prosecutor are going to throw the cop under the bus and convict him for 20 years.
I'm certainly not making any
happen.
promises on that. I'm just representing what I think is the case. I think there's a decent chance he's going to get charged. I think there's a decent chance he'll get convicted if charged. I don't think that he will win on some of these federal issues. But regardless of that, I'm not promising that like a jury might very well see it differently. But I'm just telling you what I think.
I'll bet you $20. I'll bet you $20 that he doesn't get convicted if he's charged.
Okay, I'll take that bet.
Okay, I'm gonna call
wait. Is this a moral bet? I'll think about whether or not it's a moral bet before I do it. But just thank you so much for having a conversation. It won't be the last one, and we'll talk soon.
All right, thanks, buddy.
Later, bro. Later.
All right, bye now.